field of family law in the European Union, especially concealment of paternity. The floor is yours, Maria Dolores Casas, and you have 30 minutes. Thank you.
Thank you so much. So I'm going to try to share. Okay, so okay, hope you see the slides.
Yes, we see your slides. Yeah.
Okay, thank you so much. Firstly, I would like to thank you so much. So, Ilara. So, first of all, I would like to start by expressing my gratitude to the organizers of this webinar for giving me this opportunity, is also to rethink the core areas of private law. So it is an honor for me, it's truly. So the topic I'm going to address today, the civil liability in the field of family law, especially concealment of paternity. On a day like today, the World Children's Day, so the previous speaker has talked about the interests that affect the children's. I will also point out that the interests of children will also be affected in this intervention. So in a very quick eye, I will, after a brief introduction, I will focus on some controversial cases in Euros. I don't know if we will have time, but the lack of voluntary recognition was mainly the illegitimate interference with parent-child relationships. And I will finish with the liability for concealment of paternity. And I will try to finish with some conclusion or question for you. And so in this case, we are the crossover. This is the question. The crossover, is it possible the crossover between family law and tort law in Europe? So it is two previous ideas. So it is well known, but all of you that family law is the competence of European Union countries. And so the European rules only apply in cross-border cases because, okay, more authoritative voices like Virginia Zambrano has told us that this family is very linked to our culture, heritage, society, values. It's very connected to the constitutional values that are defended by each state. So it is very difficult to unify this because on such sensitive matter. But although, okay, we can note that there are some efforts in order to unify it, like this principle of European family law, but okay, they are only recommendation. But on the other hand, the European tort law, it is the same. There is no in French expression acquis communautaire, nor, okay, because we must take into account that in every single country in Europe, there are so few articles, in Spain 10 articles, and so there are a lot of case law. But there are different interpretations, for instance, related to the element of the civil liability, loss of opportunity. Okay, and it is said that it is an area which is unfair theorized and in danger of being correctly applied. So taking into account data, it should be borne in mind that we have related to the tort law a very important legal unification document. This is the principle of European tort law, not mandatory, but it is a source of interpretation by our Supreme Court. So, okay, very quick. Okay, the impact has been studied by this authoritative doctor, Michael Casal, has impact always not only in the national legislation, but also very important on case law. It has been cited by the European Court of Human Rights. I'm going to highlight this article because it affects my topic, the duty to protect others from damage, but mainly this article, this related to we will explain later, the damage, the pure damage. What is a pure damage? I will explain later, but taking into account that it is said that when it comes down to a pure damage, we must apply the dolus, the disease, the intentional negligence. Okay, so all in all, in Spain, we can say that the principle of European tort law acquired the character of an interpretative sources. When, for instance, one tribunal has some doubt in order to adopt one solution or another, okay, this is a very interpretative source in order to, as Michael Casal says, in order to rule out a decision in favor of the victims, because it is important to recall that tort law is governed by the principle pro damnato, the principle of indemnity. So the updating of this principle should be encouraged. So the second previous idea, okay, is that in the 21st century, in which the expansion of liability is a dominant trend, Is the category of civil liability in domestic sphere an exception? Because of the principle of family immunity, today we are going that there are two opposing views. But for me, it is very important previously to look up the evolution in both continental codified law and common law. So that previously also there is a consensus, apart from, there is a consensus in these two opposing views, which is the consensus that the principle of family immunity has never implied immunity from criminal liability in Europe. The duty is the so-called ex delicto civil liability. For instance, the crimes of injury due to the transmission of sexual disease against sexual freedom or property of spouses implies, of course, the criminal liability and the so-called ex delicto civil liability. But the remaining cases, other cases, we are going to study. So very quickly, in the civil law, codified law, we have the implicit, the traditional refusal to apply tort law to family sphere because of the implicit principle of family indemnity. But in the common law, there has been the explicit, it's right, based on the marital unity. So you can think that, at the beginning, from the outset, there was a procedural a problem because it was not possible to sue to other spouse. But very quickly, I'm going to refer to England, United States, and other common law statutes. So we are going to see the differences. So in England, there has been, this Law Reform Act established the immunity from personal injury between spouses disappear. But we must state some nuances related to the concealment of paternity. Why? Because there is only consensus in England related to the married couple, not related to the married couple. So only the cohabiting spouses can sue the other spouses in order to obtain compensation, in order to encourage loyalty, honesty, and because related to the autonomy of family law, because related to the married couple, there are the so-called action, the financial remedy proceedings at the same moment that the spouse filed for divorce. So, and also there is it is very important, the no obligation to disclose marital infidelity. This is a trend in all the common law and also in the codified law. So, only apply to a married couple, but within a married couple, there is no consensus of the compensation for pecuniary damage, because in some sentence, like in 27, we can see that the tribunal award damages for moral damage and not for patrimonial damage. I would like to convey to you the reason. It's not a technical reason, but for me, it has been cited both in United States and England. The claimant had derived much happiness from his relationship with what he considered to be his son before he knew the truth. So this was the argument. And it's curious because I would like to say to you, but there are another sentence that say the contrary, that award both patrimonial and no patrimonial. So related to the United States, we have the Restatement of Tort updated in 2014. And so they based on that, admit claims between spouses, especially related to custody issues. This is a consensus about that. I have no time, but they started to establish the invalidity of clauses in the insurance contract that established the company's issues hasn't the duty to indemnify when the victim and tortfeasor from the same family. So at the end, related to the concealment of paternity, that is the other way around. Related to the England, there is consensus related to the pecuniary damage. It is not possible to give compensation for the alimony for the maintenance that the father, the non-biological father, has paid to his sons, and some states laws expressly prohibit compensation. But related to the moral damage, it's very likely the judges and the court award. But there is one requirement that must be met. Only when we are faced to dolus or deceit, failure to inform husband of outrageous. Outrageous is like more than insulting, it's shocking, is in the hierarchy the reckless disregard to another person. So we have here a landmark sentence in Miller versus Miller is very, very interesting, because the mother and her parents is an example of dolus trick the plaintiff into marrying her daughter when she was pregnant, and only after 15 years of marriage did he learn that he was not the father. So only to refer Canada, in Canada it has been very interesting because there has been a mixed response as now, okay, from the moment, from one case appeared to pave the way, because provided that men act quickly under suspicion of misattributed paternity. But furthermore, in Australia and New Zealand, we have, there has been positivized. For instance, in the family law amendment allows men to reclaim money and property given through a court. It's more difficult related to the moral damage. Okay, so all in all, in conclusion, we are faced with a question that is not closed in common law, because we have two opposing views. Once, it's the same in codified law, ones that allow this claim because the natural development of tort law, but within this position, there are different positions, because one of them say, okay, we must adapt tort law to domestic context, so there is a privilege, we require dolus. Another establish no, it is we must apply the general rule of negligence. The medium is the country of the medium diligence. We will see later. And the other is that under public policy reasons, okay, there is a prohibition on deceit claims in most circumstances. So because the marriage is still a private domain, okay, and so because in the other there are another reason that the previous speaker has told, that the paternity is not linked to biological ties but to affection ties. Okay, there are different articles, but okay, this is this related to common law. Related to codified law, I would like to highlight two ideas. The factor that contributed to the principle, because it's going to help us to understand the arguments of the Supreme Court in Spain or in another countries, European countries, are a terminological accuracy, differentiate injury and damage, because in Spain we have a problem and we use only one term to use to give reference to different reality. And so, very quick, factors that contributed to the implicit are social. I'm going to talk very quick about this and juridical technique. I'm going to go deeper in this and the autonomy of family law and practical order, because these are the argument that has been used by the Spanish Supreme Court and other country. So it is well known that in the past decade, previous to the evolution of the family law, there was a hierarchy. There is a duty of obedience, or so the universal limitations of the patrimony of the women. All of this has changed, but previously, the rule of morality implies prevent the spouse from suing the other in order to maintain the family harmony, or also the bond of solidarity and gratuity that implies in the family, implies that believes in the duty to tolerate the damage. But I would like to tell to you that nowadays the family harmony, the family unity has often already been broken up with the previous divorce, okay, and after the husband sued his ex-wife. So this is not, there has this evolution of the family law established that this factor is not coherent now. And so the juridical technique also, there is a sort of statute of limitation. For instance, in Spain, it's very paradigmatic. It's very important because we have only 1 year. In France, Germany, 3, okay, in Italy, 5 years, as far as I know. Okay, this is also another factor. But I'm going to go deeper in related to the factor of autonomy of family law. Why? This is the main reason to establish. No. Okay. It is not possible to apply tort law to family law. Why? Because there is an autonomy, because family law, the statute of family law are closed and regulate in the way the family law wants it. Okay, some relationships in a context of freedom and not under the threat of compensatory sanctions, because this is the state's duty to respect the autonomy of the family. So I'm going only to refer because I will develop later. And also it is significant that this article of the Common Frame of Reference of the private law establishes civil liability rules do not apply insofar as their application would contradict the purpose of other private laws. Is this like that? Contradict the purpose of family law, the commutative justice that governs tort law? So even though we can say that there are, okay, this is the autonomy. Okay, the autonomy, the family law respond to this problem. But okay, actually, there are few presets in all the countries, European countries, and many current problems. For instance, only to see in a very quick out, we have only this article that the government law. So it's just so few that doesn't respond to the problems. And so the second argument that I use for our Supreme Court is avoiding tribunal dispute, the so-called floodgate argument. If we can ask the judges and court can say, okay, if I admit that I award this compensation, it is very likely that there will be a lot of cases, trivial cases. But for me, I can counter-argue another, that the own theory of tort law, you know that the tort law civil liability implies five elements: action on omission, unlawfulness, antijuricidad, damage, subjective criteria of imputation, and causation relationships. Okay, the most important, not the most important, but unlawfulness is that if you commit a damage that is not covered by the cause of justification, you are not obliged to compensate. So this problem of the trivial dispute is very paternalistic, and I think goes against, okay, it's going to be resolved by the tort law, because the general risk of life is a cause of justification. So this element excludes, for instance, the possibility of suing for mere inconvenience. Okay, for instance, the non-fulfillment, it wouldn't be compensable, the non-fulfillment of the promise of marriage, of the marital conflict derived from the transsexuality of others, or even marital infidelity. So these arguments, I think, are not consistent and coherent, but there are the arguments. And so the second and the last, okay, idea related to the codified law. This is, I would like to say very quickly, a terminology accuracy. And so we must distinguish the injury and the damage. And so why? Because the injury is okay. It is said in this article. It's very okay, clear. The article of principle of tort says compensable damage requires material and immaterial harm to a legally protected interest, not only subjective right. So we have the injury or harm to a subjective right or an interest of worthy of protection, to the personal sphere, for instance, the physical integrity, the so-called bodily harm, or other spiritual right, or to the material and injury to my material damage sphere. And as a consequence of this injury, I have damage, okay, patrimonial or moral. And this is a material that these damage are compensable, not injury. So it's different. And so in this case, we will say that all interests must be compensated. This is the problem. But, okay, related to the concealment of paternity is because I say that we are faced with a pure damage. Why? What if the pecuniary and moral damage does not derive from an injury, neither personal nor material, like the concealment of paternity? Why we are faced with a pure damage? Because it's the injury to the certainty to the parental filial legal bond. Okay, and as a consequence, why? Because as a consequence of that, these relationships is going to be broke. The disappearance or diminution of the right to relate to the alleged children. So this is the pure damage. So this pure damage must be compensable. There is no consensus. For instance, in Spain, our Supreme Court has admitted the cases of false positives for a disease and the near miss, but not for the concealment of paternity. And why? Because in the majority most countries in Europe, not only in Spain, we will see later that we have an open clause. Whoever causes a damage must pay a compensation. So it is except Germany. So the non-typically of the damage. So, okay, based on this, okay, all interest worthy of protection must be compensated, but this is not so clear in our case law. So in conclusion, related to codified law, okay, paradoxically, okay, it is that it is said that there is a position that said that it is not possible to apply because it will imply the return to a framework of oppressive familial relationship from which modern family law had already freed us, because it's contrary to the welfare of the best interest of the child. Okay, but on the other hand, I think, as I was told you, okay, there are another position that say, okay, we have an open clause in the majority of most countries. So if we are faced with an interesting way of protection, we must compensate. There is more problem in Italy, for instance, because as far as I know, because they have the moral damage is regulated with the typical clause, but they have resolved through the biological danno, the same in German. But we will say in which way Germany has resolved the problem. But all of these are open clause. And so, okay, we can say that if family law does not respond to this problem, it is up to the case law to recompose the system. If not, okay, in accordance with common sense and morality. And so, okay, after this introduction, I will move on to some controversial cases in Europe. And so I will move on to the lack of voluntary. I will move on to these cases because I don't know if we will have time, because I will back sorry to this only. I'm going to name this the lack of voluntary recognition of paternity. If you are interested, is regarding the voluntary recognition and regarding to the acknowledge out of complices. Okay, but I will go backward if you are interested in that. But if not, I'm going to move on to the most important case of applying to law to family law, unlawful interference with parent-child relationships. So in this case, it is necessary to say that it was the starting point to apply to law in the domestic sphere. Related to Spain, we have to highlight this cornerstone sentence in June in 1899, because at the same time it's the first recognition in Spain to the moral damage when one parent obstructs the right of other parent to have relations with the child and prevent the exercise of custody. This is a very curious case. Why? Because it's not the typical case, because in this case was the father, the non-biological, was judicially awarded custody of the child. The mother left for the United States. The sentence could not be enforced in this country. At the end, to simplify a lot, to summarize a lot, the father claims for moral compensation for preventing him from exercising custody. So in this case, it has been very interesting. The fundamental is the open clause. And there has been very strange because, and the right to respect for family life, the Article 8 of the European, according to the European Court of Human Rights. So there are some problems. I would like to highlight that the Spanish in this case, the Spanish court has been very flexible, has been, for me, very brave in order to rule out this problem. Why? Because he has qualified this damage as continuous in order to avoid the problem of that the action was time-barred. We have only 1 year, remember. So in this case, we have told that the dies acquis is when in a continuous damage is when the damage is final. In this case, when the child turned 18 years old. So at the end, it was successful in this case. And so for me, I would like to convey to you that tort law is more effective than other measures in most European countries. The measure has changes in the custody of the minor, suspend the maintenance payment, but in this case, you can hurt the minor. So for me, it has been important. The novelty also is because we are not dealing with a case, the normal case, in which the parent who has custody prevent the exercise of the right. It's the most common case. But also in this case, you can sue the spouse in order to obtain compensation. And also this ruling is to be commended because it's taking into account the silence or lack of sensibility in these cases. Other cases, for instance, that has been brought before court. The parental alienation syndrome. The European Court of Human Rights has told that the mere refusal of the child to see the parent does not exclude civil liability. So it is for me very important. And also without obstruction, the parent breaches the visiting arrangement. Could the non-breaching parent sue for pecuniary damage and no pecuniary damage? Yes. And so there has been an evolution okay, in the minor jurisprudence in Spain, and now we can say that in most countries in Europe, all including Spain, there are consolidating current state that this damage is compensable. And also I have seen that Italy courts have granted this right to compensation for moral damage. So it is both in common law and codified law. And so it is more controversial related to marital relationship. So we have seen that in this related to the parental affiliation legal relationships, there are more or less a consensus in common law and codified law, but not related to the lack of the recognition, we will see. But related to the marital relationships is more controversial. I'm going to refer the violation of marital duties. There is no consensus in most countries in Europe, in exception in France. And we are going to see the concealment of paternity. Okay, for the breach of the duty of fidelity, I would like to see that there is a negative response because it is a duty of an ethical that lies within the extra juridical sphere. And so it is said, depends of the conscience of every single spouse. This is a not legal nature, and for this reason, this is what one sector of the doctrine established, and for the reason of the evolution of family. Okay, and given it is important, given that in general the legislator does not take into account the imputability of the conduct for the judge to impose a compensatory pension, the alimony to the other spouse when there is a divorce. But it will go deeper. When I was studying this, I was shocking because there are a lot of exceptions. This argument is not coherent because, for instance, in Poland, Lithuania, Hungary, Romania, we can say, okay, it's because their values, there are more conservative countries, but also in Belgium, Greece, and Austria, it is the same. For instance, in Belgium and Greece, the court can refuse the request if the respondent proves that there was a serious fault on the part of the applicant that made it impossible to continue living together, or because the spouse who might be entitled is to blame for the divorce. So it is the guilty here. And Austria is the other way around, but in the same, taking into account the guilty, the spouse who was solely or predominantly at fault. So furthermore, there are even so we can say all in all that the guilty of the negligence is taken into account for the judges in some European countries to determine this. But furthermore, there are even countries, France, Romania, and Portugal, that expressly regulate the right to compensation compatible with the pension, the alimony, the pension compensatory to the other spouse after the divorce, if the requirements have been met. Okay, so for instance, in France, permitted under this article, compatible, this is the open clause, like in Spain, the 1900 So, for instance, in French law, the breach of these duties may give rise in some cases, when they show a serious disregard, reckless disregard for the welfare of the other, for instance, serious repetition deriving from the public repercussion leaving home, so to unlawful damage in the extreme derelict to civil liability. So the judges, the French judges, highlight that we must separate and dissociate the moral damage from the reproach of fidelity. So in this case is not subject to reproach of fidelity. It is a question, it is a matter of moral damage, not a matter of reproach of fidelity. I'm going to put forward only two examples that caught my attention. For instance, in the minor jurisprudence in a provincial court in Orleans in 2010, when it was the wife, not the husband. The wife was obliged, ex-wife was obliged to compensate the husband because she has abandoned their family with two children, both of them with serious problem of handicapped. So in this case, there are another that, for instance, it is, for instance, one example only when there is a very serious case, no? The another in Romania or in Portugal. In Portugal also, it's very interesting. It's because, it has nothing to do, in this case, we can see that the compensation is in order to reflect the commutative justice between the victim and tortfeasor. It's not because you can see that the spouse who sustained the damage has a right to reparation for the damage inflicted by the other in the general civil liability. One, the spouse who filed for divorce, but is filed for divorce because the alteration of the mental faculty of the other spouse. So this spouse has no guilty, and this neither this nor this. When it has lasted for more than 1 year, and due to its seriousness, the possibility of living together, okay. But the spouse who filed for divorce for the reason must pay moral damage to the other spouse due to the dissolution of the marriage. So we have the example in which the alimony, the pension, compensatory pension is okay, is coordinated, okay, is compatible with this. So moving, in conclusion, moving towards a patrimonialization of family law, because we are in this trend. So there are two opposing views. Okay, there is in Spain, okay, in Europe, there is a compromise position. Which is the compromise position? Only tort law is applied to domestic sphere when it comes down to a crime or the violation of fundamental right. And law must be analyzed on a case-by-case law. Solely, okay, it is not rejected at all, but it is very limited because there are a lot of remaining cases out of the crime and the violation of a crime. For instance, the defamation of a spouse, or all the cases we are going to see later, for instance, the concealment of paternity. So there are another opposing view that also for me, the duty of fidelity, okay, it is said that is or ethical nature. For me, it is a true and proper obligation, because it is said that it is true that it is not enforceable in forced manner. It is true, but it is legally binding because infidelity has a lot of effects related to the presumption of paternity, revocation of donation. Okay. And this the model, I don't know, because okay, the institution of marriage is going to be flexible, but I think we must. I think that related to this, the maker lawyer, European maker law offers, okay, a concept of marriage that implies that it's a personal relationship in a nature exclusive nature. So because the legislative offer different family models, and every single cohabiting partner could choose the model that suits to their interests. So in this case, when you married, you have this expectation. And so we will see that also the experience in France related to that. But this does not imply duty to love the other in all circumstances, but rather to adopt reasonable measure to ensure that no harm is done. When divorce is an accessible and quick alternative in most European countries. Also, the fidelity in democratic society is a broader content, not only limited to the sexual sphere, but also affective, social. For instance, if you defend because if you defend your spouse, could not be a crime, but you can go against the dignity of your spouse, could be a kind of fidelity. It is said, and so this is related to the breach of the duty, okay, of fidelity. There is no consensus. The majority of the Supreme Court says that the breach of the duty of fidelity is not subject to compensation, but I think there are some arguments that are not consistent and coherent with the framework that we have studied. And so we finish with I finish with the problem of the concealment of true paternity. There is an increase of concealment. There is the an increase. So the problem of the increase in concealment has the sociological parallel. Perhaps I have no time, but this is a problem now. So I'm going to start with a country that grant this right, and after I'm going to follow with another country like Spain that, okay, establish that it is not possible. So for me, it's very interesting, the case law, the German case law, because grant this right in a very consistent way with some nuances, because this civil code has a very interesting article that has been applied, not because in this case it is said that as general rule, tort law does not permit a plaintiff to sue his ex-wife for economic loss, but there is an exception. The special two roles in this article state a person who in a manner offending common decency intentionally inflicts damage on another person is liable to the other damage to provide compensation for the damage. So it is related to the dolus, deceit, when you cheat the other person. So is when there is a further aggravating factor where present. So the German law has an article that has been applied, okay, in my opinion, in a consistent way. So, but we need a false statement, not a medium negligence, but at the same time, we will say later another nuance. So, however, there might be a right to claim in the wife conceived a child and the adulterant gave a false. Oh, sorry. But so sorry. After I will complement this idea. Related to the Spanish case law, there is an absolute refusal of our Supreme Court. We have two recent sentences, the 2018, 2021. Sorry.
Yes, if you just could come to the conclusions.
Okay. So
thank you.
So there is so related to sorry. For instance, for instance, in Germany, we need false statement. There would be no malice, but it's very important in Germany. But according to German jurisprudence, there would be no malice or immoral behavior if the unfaithful spouse remains in silence. But according to Spanish law, it is not possible for the autonomy of family law and all of that. But for me, the conclusion is that although our jurisprudence is not a source of law, and there is a problem that's misresolved. For me, is more coherent to adapting tort law to family law, because this is a juridical institution that is flexible in order to adapt the current problem. So for the principle of solidarity, relaxation with the standard of care and intimacy, we must apply the dolus or deceit, okay? When the spouse make false statement, establish a strategy, okay, like for instance, sorry, only to put forward an example, this is the very paradigmatic cases that you can apply. For instance, the fraudulent conduct, the long-time elapses of concealment or plotting strategy. So at the end, the principle of tort law, okay, also give arguments to recognize the dolus in these cases and not the fault or negligence. So the problem that the moral damage we have seen is that the moral damage is more accepted, okay, and also it qualifies as a permanent and non-continuing damage, but there is more problem related to the patrimonial damage, okay, because finishing, it's not possible to apply the recovery of non-undue payment because there is one requirement is not made. Okay, this was a payment. If you paid to your son when you were married and you think that you were the father, it's a payment made on the basis of a legal obligation. Okay, it is not possible to apply the civil liability because our Supreme Court has said that this is not possible. But for me, it is an alternative thesis and just enrichment. Okay, that has been followed in France and Germany, and so it has some advantages that I have no time, but yeah. I think to say that okay.
Yeah, thank you very much. This was very.
So thank you. I'm so sorry for.
No. Thank you. This was very rich. It was very interesting. And
so sorry.
No. Thank you
so much for your attention. You have some doubt.
Thank you, Maria Dolores. That was really interesting, and thank you for all this comprehensive overview. That confirms that we are indeed living in very uncertain times where we lack of points where to orient ourselves on a certain in a way we give a lot of importance to the genetics, but then there is also the social dimension, and in all this we must not of course lose sight of the best interest of the child, but also of the future generation, what we want our society to be built upon, which are our values, which are the foundational values of the future society. And so without further ado, because we are running late, I would like to give the floor to our next speaker, which comes from the host of this webinar, the university who hosts this webinar, the UNED, and this is Begonia Flores, and she will give us an overview of the protection of unaccompanied minor migrants in the EU, and you have 20 minutes. Thank you very much.
Sorry, just a minute. Maria Dolores, stop sharing your presentation.
Sorry. Oh, so sorry.
Now, thank you.
Thank you.
The floor is yours. We are looking forward to your presentation. You have 20 minutes. Thank you.
Thank you. Thank you, Professor Pretelli, and thank you for the Family and Succession Law. Each year, thousands of unaccompanied children arrive on the territory of the European Union. Therefore, the protection of these minors is a significant issue which I am going to explore here. I will divide this presentation into 3 parts. First, I will go over the definition of unaccompanied minors according to the law. Then I will move on to the legal framework, looking at the 3 levels of protections for the unaccompanied minors. Finally, I'll explain the gaps of the European law and the practical problems in enforcing the legal protections of these minors in the member states. What is meant by unaccompanied minors according to European law? It is a minor who arrives on the territory of the member states unaccompanied by an adult responsible for them by law or by the practice of the member state concerned, as long as they are not taken into the care of that person. It includes a minor who is left unaccompanied after they have entered the territory of the member state. Finally, those minors who arrive separated from an adult responsible for them, but accompanied by other relatives like grandparents, siblings, uncles, or aunts. Another fundamental question is to describe the profile of the unaccompanied children. Most of them are boys between 14 and 17 years old, and they come from African countries, Eastern Europe, and the Middle East. Why do children come to the European Union alone? To escape from the war and conflicts, discrimination or persecution, poverty, or natural catastrophes. Some of them are sent by their family to find a better life so they can send money home, or to access a better education and medical attention. They come by sea in small boats or by land, hidden under track, for example, putting their lives at risk. On the way, these children are exposed to significant dangers: violence, trafficking in human beings, psychological and sexual abuse, before and after they enter the European Union territory. The purpose of this talk is to focus on unaccompanied minors that do not require international protection and for that reason are illegal migrants. These children are in a state of vulnerability because they are minors, they do not have persons responsible for them, and they are also without papers. We'll see they are the ugly duckling in regard to childhood protection. Turning to legal framework, there are 3 levels: international level, European law, and each member state has its own legal framework and policies. First, the international level. The main instrument is the United Nations Convention on the Right of the Child of 1989, known as the CRC. In its Article 3, it states that in all actions related to children taken by public authorities or private institutions, the best interest of the child must be the primary consideration. This is a key principle for any decision related with minors and should be respected by administrative authorities courts of law and legislative bodies. Article 2 of the CRC establishes the principle of equality or no discrimination, according to which it is fundamental to ensure that any child needing protection receives it, and all children must be treated first and foremost as children, regardless of their immigration status, citizenship, religion, or any other circumstances. Looking at European law now, Article 6 of the Charter on the Rights of the Child establishes the principle of no discrimination, and Article 15 enshrines the principle of the best interest of the child. The Charter of Fundamental Rights of the European Union also recognizes this key principle in its Article 24. The European Union acquis provide a general framework for child protection in Europe, but these instruments do not lay down specific provisions applying directly to unaccompanied children. It is true that there are other documents which establish significant guidelines for the protections of the unaccompanied minors. We should bear in mind that these documents are not obligatory for the member states, who have wide margins in implementing them. Two documents should be highlighted. First, Action Plan on Unaccompanied Minors from 2010 to 2014, and the communication from the Commission to the European Parliament and the Council of 2017. Let's look at the outlines of these documents regarding the protection of unaccompanied children. First, the member states shall take measures to facilitate the return of the high number of unaccompanied minors that do not require international protection. In all cases, the return must be conducted in a safe, child-appropriate, and gender-sensitive manner. The return is not always the best option. The issue is much more complex. In many cases, the best interest of the child is not to be repatriated to their country of origin. Second, the standards established in CRC should be placed at the heart of any action concerning unaccompanied children. Third, a European common approach is needed. Currently, there isn't any legal status for unaccompanied minors not seeking asylum. At the heart of this common approach should be the best interest of the child, based on respect for the rights of the child set out in the CRC and in the European Charter of Fundamental Rights. Four, it is necessary to find durable solutions based on individual assessment of the best interest of the child. These solutions shall consist of return and reintegration to the country of origin, or remain in the member state concerned, granting a legal status, allowing minors to integrate in the member states of residence. Fifth, all the decisions on the future of each unaccompanied minor should be taken by the competent authorities within the shortest period, reaching the solution, if possible, in 6 months. The key is to assess what is the best interest of the child. Sixth, from the moment an accompanied minor is detected in European Union territory, reception measures and procedural guarantees should be applied. Specialized civil society organizations should be invited to play a more active role throughout the entire process. Seventh, appropriate measures should be taken to ensure a smooth transit to those children who are about to turn 18 years and become adults. Finally, it is necessary to introduce a mechanism to monitor the quality of the guardianship to ensure the best interest of the child is represented in the decision-making process. We will explore now 3 topics in the implementing of the protections of unaccompanied minors. First, the gaps that exist in the European legislation regarding the protection of these children. We can highlight the following. First, European legislation does not provide for the appointment of a representative from the moment these children are detected by the authorities. This is provided only for asylum applicants. It is true that the Return Directive, the Temporary Protection Directive, and the Directive of Trafficking in Human Beings establish relevant safeguards for unaccompanied minors, but a margin for interpretation is left to the member states. Second, European legislation does not state that unaccompanied minors should receive relevant information on their rights, the procedures they could be part of, the ways to claim, and the services available for their protection. Third, European legislation and policies do not address legal status of minors who cannot be repatriated. This is a paramount issue that should include these aspects: the reception of these minors, age assessment and family tracing, guardianship and legal representation, access to accommodation and care, finally, initial interviews, education services, and appropriate health care. Now it's time to go to the practical problems in enforcing the legal protections of these minors in the member states. First, there is a lack of comprehensive data about the real situation and difficulties that unaccompanied minors experience in the European Union. Therefore, it is not easy to find long-term solutions. Second, one of the biggest concerns is the great deal of unaccompanied minors in hiding, who should be in the care of the national authorities. Some are in the prey of the traffickers. Others end up working in the grey economy and living in degrading circumstances. And there are children who try to join members of their family. Third, another key point is the age assessment. There isn't a common approach in the European Union. Frequently, these assessments aren't reliable. Sometimes they are not necessary. For example, when the minor has a valid passport. On many occasions, invasive methods that don't respect the minor's right to privacy are often followed. There is hardly ever possibility to appeal. And finally, a minor's guardian or a lawyer is rarely present during this assessment. Last but not least, in many cases, guardianship of these children doesn't work properly. Accommodation facilities are not always adapted to the needs of the children, and the staff is not qualified. Frequently, individual assessments are not carried out, and the education that unaccompanied minors receive is not relevant to finding work, which is their main objective. In some member states, unaccompanied children don't have independent representation. This is necessary because the child protection authorities are often under pressure from the political authorities. Guardians play a crucial role in ensuring the children can access to their rights and in protecting their interests. But in many cases, guardians are appointed late. In other cases, they are never appointed, with negative consequence for the protection of the children, who remain limbo for years. Dramatically, this often means they escape from the reaccommodation centers. Finally, examples of bad practice in some member states. In Spain, the age assessment are ordered by the prosecutor and not by the judge. Many children with passports must undergo this practice despite the Supreme Court stating that only courts have the right to declare that a passport is false. On top of this, there is no chance to appeal the decision of the prosecutor. Therefore, many children with a valid passport are declared adults, so they cannot be protected, but they cannot access the resources for migrant adults either, because they have a passport according to which they are minors. In France, the courts order the age assessment and decide if the migrant is a minor. The problem is that 75% of the appeals are successful, but it takes years to obtain a response from the court. And in the meantime, these children, declared adults, remain on the streets without any protection or support. In Germany, the appointing of the guardian takes a long time, and often the oldest minors are accommodated with migrant adults, then without the protection appropriate for children. In conclusion, the different authorities in the member states perceive unaccompanied minors as significant burden that puts the administration under pressure. The consequence is that the different administrations are reluctant to enforce the law or to improve it. For this reason, it is urgent for the European Union to approve a directive which contains a legal status for the unaccompanied minors not seeking asylum, with obligatory standards of protection for all the member states. Thank you very much.
Thank you very much for this wonderful overview and, of course, the ideas. Yes, the appointment of a guardian is indeed an important question, as it is the recognition of kafala sometimes, because sometimes guardians are appointed when there is some reference in the country, some uncle, and who speaks the language of the minor, which is also which would also be important to recognize. So thank you again for this, and also to respect the timing. This is very much appreciated, especially today. And without further ado, I would like now to give the floor to Jens Scherpe from the University of Aalborg and the Nordic Center for Comparative and International Family Law. That we are all eager to listen to your presentation. Jens, I just hand over it to you directly. Thank you very much for being with us.
Yeah, thank you. And my apologies for joining late. I had an appointment that I could not move, but I hope I'm reasonably coherent now. So surrogacy, obviously controversial topic, and it is interestingly not regulated in Denmark at all at the moment. The children's law, the Børneloven, states that any contract to hand over a child to another person after birth is invalid, and that the woman giving birth is always the mother of the child, and this also applies extraterritorially. So when this happens outside of Denmark. So in case of surrogacy, therefore, a woman can only become the legal mother of a child born through surrogacy through adoption. And that also, of course, applies for a second parent of any gender. The problem is that this adoption can only happen according to the adoption law when this A is in the best interest of the child and B, absolutely no payments have been made to the person consenting to the adoption. And of course, that is not the case in commercial surrogacies. The primary intent of this is to prevent the sale of children in adoption cases, but it's quite clear that even when this was contemplated, surrogacy was already on the mind of the legislatures and it should apply equally. So the idea is the prohibition of commercial surrogacy. So the facts of the KK case, which triggered the bigger debates in Denmark and the law reforms that I will discuss and indeed criticize later. There are two children, twins, born in 2013 in the Ukraine as a result of a commercial surrogacy arrangement in which the sperm of the husband and the intended father was used. It's unclear whether the wife and intended mother contributed her genetic material as well, because it is actually utterly irrelevant under Danish law. A payment was of course made to the clinic, and a part of that payment was given to the woman giving birth, and the children were handed over, and they lived happily in Denmark at the time the cases were brought. According to Ukrainian law, of course, the Danish husband and wife were the parents of the children. However, this does not interest Danish law very much. According to Danish law, the husband was the father of the children because his sperm was used. Sperm always wins. But the Ukrainian woman was regarded as the mother according to Danish law. Again, the genetic contribution of the female side is utterly and totally irrelevant. So, by virtue of his sperm, the father got parenthood, and as a result, the children got a Danish nationality, a passport, and they indeed lived in Denmark with the intended parents. The intended mother was given the Danish equivalent of parent responsibility, but any legal attempts for her to be recognized as the legal mother through adoption were denied by the authorities because payments were made. She took a case to the court without success in Denmark. So the Danish highest court, the Højesteret, in the final instance found against her with 4-3 votes. Interestingly, the only female judge was in the minority here. The majority conceded that the right to respect for private life of the children indeed required looking at the individual circumstances of the case. Therefore, an absolute prohibition of any recognition of parenthood of the intended mother was not in line with the jurisprudence of the European Court of Human Rights, and Article 15 of the Danish adoption law had to be interpreted accordingly. The majority also conceded that it would indeed be in the best interest of the child to allow the stepchild adoption, but they found that the general preventative intention of the legislation, namely to prevent commercial surrogacies, exploitation of women, and the sale of children, would weigh heavier, especially since the family could live in Denmark together without any major problems and disadvantages, which one may doubt, and the intended and social mother had parent responsibility and could be fully involved in the life of the children. The minority in the Danish court came to the opposite conclusion in light of the rather clear European Court of Human Rights jurisprudence, and held that an adoption order should have been permitted, as the best interest of the concrete child in question should prevail over general preventative intentions of the legislature. Somebody must have had deep pockets, because this went to the European Court of Human Rights. And there, in an equally narrow decision, the court held that not allowing the adoption of the children would be a violation of the right to respect of private life of the children. Following the court's earlier and rather clear jurisprudence, it was held that the margin of appreciation of the national legislature was limited when it came to highly personal and sensitive areas in the area of personal life, and in particular, the right to identity. The disadvantages that the child suffered by the intended mother not being recognized as the legal mother outweighed any general preventative intentions. In short, being like a parent for the children was simply not the same as being a parent. Certainly not with regard to the issues of child support, inheritance, and so on. Moreover, and that was one of the key arguments as well, there was actually no other person who was really interested in being a parent, or indeed could be a parent to the child. Now, my views on this. First of all, I already mentioned this, according to Danish law, the old position, sperm always wins. The man, essentially, if they provided the sperm, always gets what he wants. The second parent more often a woman than not, but of course it applies to male same-sex couples as well, irrespective of the genetic contribution. So even if the woman had contributed her egg, always loses out. Sperm always wins. Why is sperm more important than egg? Why are women with fertility problems disadvantaged? Men with fertility problems can become fathers without any problem in Denmark, but women with fertility problems cannot. But even more worryingly, the Danish position is premised on the idea that there is a deterrent effect, that this prevents surrogacies and exploitation and commodification and so on. And all of these concerns, of course, are fully justified. Nobody denies that. But imagine the social situation. If you know that in Denmark, under the old law, the man, the husband, your partner, the love of your life, will become the father of the child through surrogacy that you wanted with him to start a family, and you know that you can be this family, that he can have a child that is legally his and genetically his, and that you would be, while not the legal mother, you'd be like a mother, because that's what Danish law allows you to be. You can be like a mother. Is that not better than not being parents at all? Surely, if your intent is to both raise a child together to become a family, this minor inconvenience of the second partner, the woman usually, not being the legal parent at all, is not deterrence at all. So the general prevention fails completely under the Danish position, as the case in question shows, and indeed the many other cases we've already had in Denmark. So the only way this deterrence would be achieved in Denmark if we also not recognize the parenthood of the father. But of course, that would effectively deny the victory of the sperm, but also effectively deprive the child of any parents in Denmark. And of course, in the Ukraine, the child would not have any parents either, because under Ukrainian law, the Danish people would be the parents. So given that under the old Danish law, the general preventative effect wasn't really working, the argument of general prevention cannot really justify the extremely severe infringements of the best interests of the child. Now, of course, there can be no doubt that some or even many surrogacies are exploitative. They commodify children, the woman's body, and they violate the dignity of the persons concerned. But equally, there's no doubt that the children concerned are absolutely innocent regarding the way they were brought into this world. And whether we like it or not, commercial surrogacies are happening. Whether or not this would be desirable, an effective global ban on surrogacy will not happen. The desire of some children to have, of some people to have children is so strong that they will do this. And when they come home, we then need to decide what happens with these children and their intended parents. There's a quote that I keep repeating. It is from Justice Headley in one of the first decisions from England and the United Kingdom in a case called Re X and Y. And he said, what the court is required to do in this situation is to balance two competing and potentially irreconcilably conflicting concepts. Parliament is clearly entitled to legislate against commercial surrogacy and is clearly entitled to expect that the courts should implement that policy consideration in its decisions. Yet it is also recognized that as the full rigor of that policy consideration will bear on one wholly unequipped to comprehend this and let alone deal with its consequences, i.e. the child concerned, the rigor must be mitigated by the application of the consideration of that child's welfare. That approach is both humane and intellectually coherent. And here's the key sentence. The difficulty is that it is almost impossible to imagine a set of circumstances in which, by the time the case becomes before the courts, the welfare of any child, and particularly a foreign child, would not be gravely compromised, at the very least, by the refusal to make an order. In other words, ultimately, we will always have to make an order, and the KK decision confirms that. So that's where we were stuck in Denmark. So we have proposed reforms, and in Denmark it is customary to seek broad agreement amongst all the parties, and there's a multi-party agreement in place. So we are very likely to see legislation coming into place from January on. It was quite interesting how deliberately short the consultation periods were, but I shall not continue to comment on that. So the new legislation will have two tracks. The first is a purely national one. So for Denmark, altruistic surrogacy is now officially to be recognized and regulated if the procedure followed by the intended parents if that is followed, then they become the parents from birth. So there's no further recognition recognized. But it's only for altruistic surrogacy, whatever that may be. So the requirements in Denmark will be for this, that the surrogate is at least 25 years old, that she resides in Denmark, that she has at least had one child of her own, that absolutely no payments have been made, and that there's a genetic link between one of the parents and the child. But do note that it's not necessarily the sperm. The egg is fine. One parent is sufficient. There's lots of problems with this. My favorite one being that even as soon as you pay the taxi for your surrogate to go to the hospital to give birth, you have made a payment. And then you're falling off this track. And it's no longer altruistic. Anytime, any payment is not valid. I will not continue to go on about the payment question. That perhaps we can do at another time. But the most absurd thing is that there actually is a legal prohibition of the medical profession to engage in surrogacy. They're forbidden to do it. It's actually a criminal offense. And this criminal offense actually was confirmed. So we will now have regulation in Denmark from January on, potentially, that allows altruistic surrogacy, but the doctors are not allowed to do it. And I find this a bit strange, to say the very least. But perhaps that will be changed in the run-up to the law, because this is so absurd that even the daftest politician must see that this cannot work. Interestingly, facilitating surrogacy agreements and advertising for surrogates and intended parents will also remain a criminal offense in Denmark, even though the provisions were never, ever enforced or applied. So the result of this is, if the law actually comes into place as it stands, we can't have surrogacies in Denmark, so people will have to go elsewhere. If the politicians see common sense, chances are we will have some surrogacies in Denmark, provided the doctors are actually allowed to do it. But as I said, there were two tracks. The second track is the international one. International surrogacies, or rather parenthood arising from international surrogacy, will now be recognized automatically if the surrogacy agreement was presented to the Danish authorities before the pregnancy is established. One intended parent in Denmark has a genetic link to the child. The documentation concerning the transfer of the parenthood from surrogate to intended parents is notarized or equivalent and available. The surrogate must reside abroad, so obviously the international track does not apply if she resides in Denmark. But interestingly, payments can be made. So we will accept commercial surrogacy, or rather the result of commercial surrogacy, i.e. the child in case of international surrogacies. So where does that leave us? So as a starting point, interestingly, really, the base position is unchanged. Altruistic surrogacy is tolerated, commercial surrogacy is prohibited in Denmark. That hasn't changed. And essentially, that is somewhat comparable to the position that the UK and many other countries effectively reached quite a long time ago. And that has shown itself not to really work in practice, and also not to prevent or at least discourage surrogacies. So the positive thing about the new legislation is that there are easier pathways to the recognition of parenthood, as this is in the best interest of the child. Then the most negative element of this is that we are continuing to turn a blind eye to the potentially exploitative practices in other jurisdictions. Because under the new law, we stand in Denmark, we pat ourselves on the back and praise ourselves for our extremely high moral standards, that we will fight exploitation and commodification because that is unacceptable. And we may actually succeed within the borders of Denmark. Well done is all I say. But the real effect of the new legislation will be, and we've seen this in the many comparative studies, and indeed one or two of my own, that the commodification, the exploitation, all the horrible things that surrogacy can do will happen. They will just happen elsewhere. So we are effectively exporting surrogacies. We are promoting surrogacies abroad because our own people, the lovely Danish people, will go somewhere else where, as the Danish state, we have no control of human rights, of health and safety. We cannot protect the surrogates, we cannot protect the children, and indeed we cannot protect the intended parents. Moreover, this also creates, rather atypically for Denmark, an element of wealth discrimination, because it is only those who can afford it that will be able to go abroad, avail themselves of the surrogacy services available. And we do know there's a hierarchy. If you have a lot of money, you go to the US of California. If you have, medium money, you go to some of the European or South African jurisdictions, or maybe Mexico. And then there's other markets which are even cheaper. But if you don't even have that kind of money, you will remain childless. So if you're rich, you can get what you want, and you can get it easily, and it will be recognized. And if you're poor, it's tough luck all around in your life. So therefore, the only reasonable way forward actually would have been a form of regulation that allows for surrogacies in our own countries, where we can make sure that there is no exploitation, that there is no commodification, that all the people involved, particularly the surrogate, but also the children, of course, and the intended parents, are protected. And that may well mean that we have to accept compensated surrogacies, as problematic as that may be. The alternative, turning a blind eye to the exploitation that inevitably will happen elsewhere, means that we will be complicit to it. I've given a similar presentation before, and the main criticism was, but will it solve the problem once and for all? No, of course it will not. More permissive regulation in our home jurisdiction will not end all exploitation and commodification. It will still happen elsewhere. But it is very likely to reduce the number of cases where there is exploitation and commodification. And if we receive a significant reduction, that is something well worth fighting for and legislating for. Thank you very much.
So thank you very much, Jens, for this for your overview. And it's really, it's really difficult to accept the reality as it is, as you pointed out. And this testifies, I believe, to the what we were saying before. So this disorientation in the light of the changes that are happening, and the discrimination of genetic mothers, as you pointed out, is completely difficult to understand. It's very difficult to understand because their situation is really exactly the same of that of a genetic father. But legislation, or well, this assimilation, this equation has not been yet done, but I am confident that it will be done very soon. And as regards the development, I think the social changes that are happening need to be metabolized. And of course, this contribution that you are giving are very helpful to that end. And also the experience of that we will now have with the migrant. This is also why we put some intervention here in this webinar with migrant. The experience of migrant families are also helpful to see how family law is evolving around the globe, because this is, as you point out, this is not only a problem within our borders. We have to consider the global dimensions, and so it will be difficult, as you state. I think it will be difficult to have a global ban on surrogacy, but maybe it is possible to have a global regulation on surrogacy. At least that's what we are working for. So thank you very much again, Jens. And now I would like to invite Vito Bumbaka, our next speaker, to join this panel. He is talking exactly about asylum and family status across borders. Vito Bumbaka is welcome Vito, and he comes from the University of Geneva, and he has a lot of experience in the field, many experiences. I will not list all of them, but I would like, because I'm really eager to listen to you, Vito. Thank you for being with us.
Thank you very much indeed, Ilaria. Can you hear me?
Yes, we hear you very well and we see you very well. Thank you.
Thank you so much. And I would like to thank also the other members of the European Law Institute who invited me today. I sincerely apologize for the delay. I could not participate in the previous sessions. I had the teaching obligations in Lyon in France, and so that's why I could not make it. I apologize again. So the topic I've selected represents the research of my habilitation thesis in Switzerland. And the idea is to assess the notion of access to justice applied in context, meaning on the parallel access to asylum and civil protective measures, civil remedies. I focused not only on the internationally transversal legal framework, trying to overcome this never-ending separation between private and public law, private and public international law, when dealing with statuses in asylum movements, but also trying to understand the practices in specific jurisdictions, Australia, Bulgaria, China, Ghana, Moldova, Morocco, Russia, South Africa, Switzerland, and the UK. In some of them, I've conducted already research on spot. On others, in other jurisdictions, I'm planning to move there in some coordinated missions with specific organizations, particularly NGOs and intergovernmental organizations that have massively worked on children on the move. And one of these organizations is the International Social Service, with which I'm in contact and where I've worked. So the other specificities which I cannot touch upon here, but I shared a paper that I think it can be shared with the audience. So specific topics can be, of course, relating to asylum, can be abduction, age assessment, recognition of marriage, transfer of asylum, family reunification, trafficking, and of course it was already cited before, but by a person who is far more expert than myself. Surrogacy is also related to asylum, of course. The accent, therefore, of the research is not only on the European Union, as Dr. Pretelli said before, but of course, asylum refers also to the transnational situation generally, globally speaking. Also indicated by the jurisdictions I'm trying to assess. And the idea is, as I said, is of course to assess the parallel procedures on asylum and civil law protection, but more specifically is also to understand how conflicting judgments, conflicting administrative decisions, conflicting social services reports. This is what happens also in practice, and I will come back in a few minutes. May ultimately end in a denial of justice, as I indicated on the notion that I've indicated before. As I said, I don't have time to deal also with the different typologies of asylum and with the provisions, multiple and many provisions governing asylum movements and the cross-border family movements. But many of these provisions are indicated in the paper that I've shared. So how to summarize? I think the best way is to go through practical scenarios case scenario number 1 refers to a multiple decisions among other actors involved, multiple decisions of the Swiss courts, Swiss Federal Court, and the Swiss Administrative Court. So in this case, a migrant a child whose asylum status was attached to the father, moved from Greece to Scandinavia, and then through Scandinavia, the child was relocated by the mother to Switzerland, allegedly abduction argued by the father. The mother pleaded for domestic violence and applied for asylum in Switzerland. Already there were 2 asylum requests. One was in Greece, supported by the father of the child. The other one was in Scandinavia, in Finland, namely, and the third one in Switzerland. The mother and the child lived in Switzerland for 3 years during the procedure, the asylum procedure, and the father went back to Greece. The father, as I said, raised the issues of abduction and so filed for return from Switzerland to Greece, or disregarding Scandinavia, the period of time passed in Scandinavia. And this return procedure was parallel to the asylum one in Switzerland. Asylum was not granted in Finland, and the asylum decision in the asylum procedure in Greece was pending. So that was the state of the asylum procedures. The Swiss Federal Court, so the case went all through the courts in Switzerland, and the third instance, the Swiss Federal Court decided on the return of the child to Greece, disregarding so the domestic violence and all the 3 years of residence with the mother. The child was, of course, a newborn, so was related. Had a dependency relationship with the mother, and on that element, the Swiss Administrative Court, in parallel on the asylum request, decided that the child should remain in Switzerland. So how to deal with such conflicting decisions internally in Switzerland, of course, but also on the vacuum of the previous asylum requests in the previous countries, and also on the fact of whether dependency relationship should prevail over the return procedure technicality under the 1980 Hague Convention. There is another element that is important, is that there was a report, a child assessment report made by the Greek authorities, which stated that the child return to Greece would be safe, and a child assessment report from the Swiss social services saying that the child should stay in Switzerland with the mother. So 2 conflicting judgments, and 2 social services reports or child assessment reports, conflicting reports, and asylum requests lacking continuity. The questions, of course, the questions that arise are many. We try to answer to this question, edited the book related to this research, and the bottom line, the guiding principles are found, according in our view, in the 1989 Child Rights Convention. 2 main principles. One was cited in the previous and I guess also in the previous sessions, the child best interest, universal principle, but the other one is the family unit. And of course, the dependency relationship is an element that is also taken into consideration in practice by courts, both national and regional courts, namely the Court of Justice of the European Union. So these 2 principles, and more importantly, the Convention on the Rights of the Child, should guide the transversal legal framework, because on the asylum request, the Dublin III regulation was applicable. And now the reform on the transition, after transition period, there will be the reform But on the, as I said, on the civil protection, there was the 1980 Hague Convention, how to coordinate this legal framework, and more importantly, how to make sure that the authorities, administrative and or the judicial authorities could coordinate towards adjudication, coordinated, more importantly, coordinated adjudication. So the outcome of this decision, in our view, was that the child should remain in Switzerland with the mother. This is also what the UK practice among those that we assessed would tend to conclude in the decision G versus G. The UK Supreme Court 2021 said that, and I quote, that the asylum procedure shall consider the child's best interest, and so it should first end and prevail over the return procedure according to the 1980 Hague Convention. Of course, the UK now does not apply any longer the Dublin regulation, and maybe we'll see later for the reform. So case scenario number 2, I wouldn't take a lot of time on this because surrogacy was already fully discussed before. But the idea is that also on the question of surrogacy, we have an element of international surrogacy, we have an element of migration, and this is assessed in the current war in Ukraine. There were some cases dealing with surrogacy in Ukraine, between Ukraine and continental Europe, and how to deal with the asylum request, refugee request, pending request, for instance, in the continental Europe, in France, and how to deal with in case of disputes between the intended parents and the surrogate mother, how to deal with the return of the child if the mother moved first to continental Europe and then goes back with the child to Ukraine. There is, of course, once again, the 1980 Hague Convention that applies for the question of return if the intended parent is genetic parent, and if custody would be assigned to him or her, and to him in case of the intended parent, and or vice versa to the surrogate mother if Ukrainian law wouldn't apply, because Ukrainian law does not provide the principle of mater semper certais. And that's on the way of civil protection. On the question of custody, the 1996 Child Protection Convention governs the question of custody, but there is also in parallel a gross bulk of provisions applying to the status of refugee status, namely the 1951 Refugee Convention, which applies to the person being outside his or her own state. What is the own state of a child, of a surrogate child, whose identity might be impacted by recognizing surrogacy, and ultimately the impact on the law applicable to parental responsibility, once again on the issue that I said between whether Ukrainian law applies or French law, given that I mentioned French law applies. So these are issues that should be dealt with, and the fact of the genetic link, of course, it's an element that would also support the custody determination. But on the question of family reunification, the Court of Justice of the European Union, the Luxembourg Court, said that regardless of the place of birth, in my example, the child was born in France and then relocated to Ukraine, the child should also be entitled to family reunification, regardless of the place of birth, according to the Court of Justice of the European Union case 230/21 of 2022, which I will cite also late. So the question of asylum has as an impact on also on the question of whether the child should return to his place of birth. For the Court of Justice, this is not an element because this is regardless the place of birth. But we have the issue of the law applicable to parental responsibility, whether it's Ukrainian law or French law. Also, if we raise the question of habitual residence, because a child who is relocating might not have established yet habitual residence, so there are some formal conditions that should be considered, which I considered in this paper. Case scenario number 3 refers to the protection of adults, because in the question of asylum family statuses, we also have to consider the those adults who are affected by dementia or by physical conditions that will qualify them as incapacitated. In that intersection, so on the asylum procedure, on the legal framework governing the asylum procedure, we should also consider the Hague Convention 2000, and that's a convention that applies to not to many states. It applies to Switzerland, and but it doesn't apply to all the European states, and of course not outside Europe. So that the 2008 convention is also related to the UN Convention on the Rights of Persons with Disabilities. So these are two conventions that are interconnected, and the UN CRPD is of course the universal instrument, universally ratified. The question here is how to guarantee access on one hand to asylum of a person that is incapacitated, and its relationship with the persons that accompany that adult, because it might, in many cases, that we assess the adult is accompanied by related family members, and so how to ensure him access to asylum and the continuity of the asylum decisions in different states. If it is in Europe, of course, Dublin 3 applies, but how to deal with the relationship between member states and non-member states, so third states and countries of origin. And how to ensure in parallel the continuity on the civil law protection, meaning the guardianship, for instance, or if there is a separation with the family related members, how to ensure family reunification on the in parallel. The 2008 convention provides flexible criteria, because the state of physical presence as a condition allows for the measure of guardianship, for instance, to be issued and later to be recognized among the contracting states, for instance, among states that move that are contracting states to the 2008 convention. But how to deal with the cooperation between countries of origin, for instance, on the recognition of administrative questions, the marital status, the family acts, and the property acts. These are also questions that should be dealt with. And on that point, we should also interrogate ourselves on the role of embassies, consulates, and civil registers. How the role could be enforced or reinforced in such procedures. An issue is, for instance, that one of undocumented migrants, which represent also another issue per se, and that we included in the research, and in particular also how to deal with the recognition of documents such as mandate for incapacity and medical certificates stating the incapacity of person of the adult in question, and the rights and the obligations incumbent on the person accompanying the adult that I mentioned before. These documents, the recognition of these documents from the country of origin, prove hard to trace. Case scenario number 4, that's a case, a preliminary ruling of the Court of Justice European Union, which I've mentioned before in relation to to the case scenario number 2. This decision concerns the intersection of domestic conflict of laws and the Council Directive of 2003 of the European Union on the right to family reunification. Family reunification I've already indicated. The facts are these ones. So a marriage there is a marriage between a minor girl of Palestinian origins, 15 years old, and an adult of Palestinian origins, which is celebrated in Lebanon. The marriage is celebrated in Lebanon. The husband relocated to Belgium, and the wife, the minor wife, wants to join the husband in Belgium, but she's considered an accompanied minor by the Belgian authorities under the meaning of the directive, the Council Directive 2003. And so a guardianship measure is issued by the Belgian authorities in Belgium. Later, because the marriage certificate is refused, and based on the Belgian private international law rules, and so in the Belgian public policy, so the child is considered as an accompanied, but the family of the child, of the minor wife, wants to join their daughter in Belgium, and so they ask a visa, family reunification visa, and this is refused once again, because the family family reunification visa cannot be asked, given the fact that the child is the minor wife, and the child is not anymore a part of of her parents' nuclear family based on the directive, which is also one of the elements enshrined in the Dublin III regulation. So the Belgian courts moved the case and asked for the preliminary ruling of the Luxembourg court, and the Luxembourg court referred to the directive, and I cite which says that to provide the directive, the objective of the directive is to provide more favorable conditions for refugees for the exercise of their right to family reunification, since their situation requires special attention on account of the reasons which oblige them to flee their country and prevent them from leading a normal family life there. Rejecting family reunification on the basis of the marital status for the Luxembourg court would fall against the special protection indicated in the directive, and particularly in the case of unaccompanied minors, as was the status recognized by the Belgian authorities. The protection of accompanied minors shall apply equally, according to the court, regardless of the marital status, which doesn't prevent the child from being subjected to violence and forced marriage. So the two of the important principles that were stated by the Luxembourg courts were precisely those that were indicated at the beginning of my intervention, the UNCRC, and so the best interest of the child and the family life, family unit, which should guide these decisions. These scenarios are just a few among those contemplated by the research. The idea of this research is also to overcome some opinions, and so that sometimes we think that asylum seekers belong to a category that stands apart, and this is true, as these case scenarios show, because the asylum seekers, they celebrate marriage, they hold assets particularly in the country of origin, but also in the country of residence, and sometimes in the country also of transition. They are constitute families, and so they have rights and obligations towards their children, and so they deal with issues such as custody, maintenance, and care. Asylum seekers are also unaccompanied, as we said, and in many occasions they might be placed in foster care or institutional care as a last resort. And so these are also measures that shall be considered in parallel with the asylum. In the case of relocation from one country to another, the measures implemented in one country should be recognized in the other country for sake of continuity. This is the idea also of the Hague Conventions that have cited both the Child Protection 1996 and the 2000 Hague Conventions. And so how to ensure that all these authorities are trained and they work together for the correct implementation of the gross bulk of provisions of the instruments. We cited few, but there are in detail also other important instruments that apply to this transversal issue of parallel procedures. And so stakeholders participate in important multilateral sessions. There is a concrete case, which is the one of the Permanent Bureau of the Hague Conference of Parties International, which has developed a guide applicable to unaccompanied minors, which is the result also of the important training and missions that were taken together with other agencies, international agencies, obviously, broadly speaking. So the UNHCR and UNICEF, so also in the context of the war in Ukraine. In terms of formal conditions that I've mentioned before, applicable to the protection, civil law protection, I think a good example is the 1996 Hague Convention, because it applies to the protection and representation of children, including accompanied minors seeking asylum, and Article 6 of this convention, but also I mentioned it before, the same article in the 2000 Hague Convention for the Protection of Adults allows the protection, civil law protection, based on the physical presence of the child and of the adult in the 2000 Hague Convention. But public measures are instead excluded from the material scope of this convention. For instance, as it was indicated, children, including accompanied minors, are not only entitled to be to access civil measures such as foster care, but also education and health as fundamental rights. And these rights are, of course, incumbent on the responsibility of states, international responsibility of states, by virtue of the UN CRC in the case of children. Another question is the question of cooperation. I already said before how to ensure that the authorities, administrative and the civil authorities, can cooperate. The 1996 Hague Convention, the 2008 Convention, they give also an example in the cooperation, because they allow the recognition not only of judgments and permanent measures, but also provisional and urgent measures in different countries, of course, in the contracting states. And I think this the cooperation as meant under the 1996 Hague Convention and the 2008 Convention is a good example of flexibility in supporting interagency cooperation to occur, also in the framework of asylum. So just to conclude, I think because the time is flying, and so the conclusive remarks is that in terms of methodology, we are planning to collect testimonies in specific jurisdictions, so the jurisdictions that I mentioned before, and including with the support of, as I said, intergovernmental organizations and non-governmental organizations. And that is to try to present these testimonies and practices before an international workshop. And a recommendation in terms of material objective of the research is trying to the objective is trying to assess the possibility of having a more pragmatic instrument overcoming the separation between private international and public international law that I've mentioned before on three main aspects. The first aspect is the responsibility, both under state responsibility, both under private and public international law, to trying to assess the possibility of having common grounds over the context of a child and family statuses in asylum scenarios. The second aspect is the recognition of civil status in asylum contexts, with the support also of organizations such as the International Commission on Civil Status. The third aspect is the cooperation between administrative and judicial authorities in the framework of parallel procedures. The idea, instead of having a single regulation at the regional level, in our view, could hardly ensure governance without a holistic assessment of all these issues that we mentioned, in particular on the three aspects that I just indicated. Ultimately, a lack of coordination and adjudication on asylum and civil protection, as we have seen in the case scenario number one, but also in the question of recognition of marital status, would hold effects towards the integration of human beings in distress, and this is the main target of the research. In our view, such a idea of having a transversal instrument should, the point of departure should be the Global Compact for Migration 2018. And that's an instrument that, of course, is a soft law instrument that is also the result of transversal interagency work on migration, on children on the move generally, and try to allow also to enforce this cooperation between different intergovernmental organizations, as I mentioned before already, the Hague Convention on Private International Law, but also to include the UN committees on the rights of the child and on the protection of persons with disabilities. So trying to allow a better coordinated work on this issue. I think I would prefer stopping there, but please, if you have feedback, do not hesitate to share. Thank you so much.
Thank you, Vito. Thank you so much for this this overview. Really interesting and inspiring. We have to integrate migrants and asylum seekers and the condition of an accompanied minor to the whole debate on social families, white families, and your experience and input are very inspiring, I have to say, to our discourse. So I would like now to hand over to Francisco, who will animate the last part of our webinar, and in particular the session on question and answer. Thank you also for the really for everything, for the time frame and everything. Thank you.
Sorry, we have the final participant. We have Abigail, who had this problem, and now
apologies, Abigail. Sorry.
Oh, it's okay.
Yes.
I hope you can hear me now. Do you hear me now?
Perfectly.
Yes.
Perfectly.
Okay. I'm so sorry for all the inconvenience, and I want to thank Professor Jimenez for giving me this opportunity and to participate in the webinar. So I'm going to start right now because we are quite late. Today I'm going to talk about digital parenting. Digital parenting can be understood as an extension of parental responsibility without the context of new technologies. As minors spend an increasing amount of time online and access social media platforms, video games, and online content, the need arises to protect the rights within the digital sphere. Parental supervision is no longer limited to the physical realm. It now also encompasses the virtual environment where parents must safeguard their children's safety, privacy, and well-being. The concept of digital parental authority entails a duty of care that goes beyond traditional physical or educational oversight. It involves supervision, how minors use digital technologies, ensuring that such use is safe and appropriate for their age. This concept includes protecting against online dangers such as cyberbullying and exposure to inappropriate content, as well as defending their privacy and preserving their digital identity.
Sorry, Abigail, do you want to use your presentation or?
No, it's okay, because then well, I don't know how we're going to pass it. So if you don't mind, I won't use it, well, if it's okay with you.
Okay.
Okay. This concept includes protecting against online dangers such as cyberbullying. Yes, however, this responsibility presents numerous challenges as it requires a delicate balance between parental control and respect for the minor rights to autonomy and privacy. Today, the use of electronic devices and internet access is commonplace among minors, increasing their exposure to both risks and opportunity. Social networks, messaging applications such as WhatsApp, video platforms like YouTube, and online video game are just some of the digital tools that are part of young people's daily lives. While these tools offer opportunities for learning and socialization, they also present risk, including exposure to inappropriate content, dangerous interaction, and potential compromise to their personal data. In the digital environment, minors are exposed to addictive design practices implemented by digital platforms to retain their attention. These addictive patterns, such as infinite scrolling, automatic video playback, and persistent notification, are designed to encourage prolonged use of application. This mechanism exploits emotional and cognitive vulnerabilities, especially in minors, who lack the maturity to recognize and resist their effect. Digital parental authority thus face the challenge of encountering these practices, protecting minors from their consequence. The digital identity of minors, that is, the footprint they live in the digital environment, and which in many cases begin from the birth, often with the involvement of their own parents, becomes a topic of concern. In many cases, parents publish photos and personal information about their children on social media from an early age without considering the long-term consequences of this practice on the child's privacy. This phenomenon, known as sharenting, raises questions about the construction of the child's online identity and respect for their privacy and intimacy. Rights that should be protected under legal parental authority. In Spain, the concept of digital parenting is not specifically regulated, but is based on an extensive comprehension of our civil code that establishes parental rights and duties in general terms. The law grants parents the responsibility to look after the safety and development of their children, which now also includes the digital environment. This traditional framework of parental authority is completed by a specific provision in the organic law on data protection and guarantee of digital rights and the General Data Protection Regulation, which provide guidelines on the processing of minor personal data and establish, for example, a minimum age for digital consent on digital network, which in Spain is set at 14. Additionally, the organic law incorporates specific provisions on digital rights applicable to both adults and minors, and reinforce the idea that parents have a duty to protect their children in the online environment. However, the regulations do not provide concrete guidelines on how supervision should be exercised in practice, leaving parents with the task of interpreting and balancing the principle of protection and respect the privacy. One of the key challenges for parents in exercising digital parenting is the influence of addictive patterns on minors' behavior. Strategies such as an intermittent reward or fear of missing out seek to maximize connection time, creating habits that are difficult to control. This pattern complicates the task of limiting screen time for parents, as minors, due to their vulnerability and ongoing emotional development, are often drawn to this platform. For parents, recognizing this pattern as setting effective limits is an essential challenge in ensuring their children's digital well-being. Supervising minors in the digital environment present a series of ethical and legal challenges. Parents must decide to what extent it is appropriate to intervene in their children's internet use and social media activity without invading their privacy. This balance is difficult to achieve, as a strict supervision could be perceived as intrusion, while too lax supervision could expose the child to significant risk. In this context, parents must act in the best interest of the child, ensuring their safety while also promoting their autonomous development and capacity to responsibly navigate the digital world. The aforementioned case of Sharentin illustrates one of these tensions. Posting images of the child can be seen as an exercise of parental authority, as it exposes aspects of the child's life from a family and social perspective. However, this practice raises questions about the child's right to decide how they are presented in the digital environment. Future judicial and legislative decisions will need to address this situation to provide greater clarity on how to protect the child's rights without interfering with their autonomy and personal development in the digital sphere. On a practical level, this tension also manifests in the right of parents to supervise the digital content their children access, such as social media profiles, browsing history, or the application they use. The lack of a specific regulation on how this supervision should be exercised creates uncertainty, leaving parents in a complex position where they must balance the duty protection with the respect for the minor's independence. One of the fundamental rights of minors in the digital environment is the right to privacy. This right is recognized both in the Spanish Civil Code, which regulates parental authority, and in a specific regulation on personal data protection, such as the mentioned before. This right implies that the minor should be able to enjoy a personal space in the digital environment, free from unnecessary invasion or interference, even by their own parents. However, the minor's right to privacy faces the parental duty of supervision, as parents are responsible for protecting their children from potential online threats, such as cyberbullying, grooming, and/or exposure to inappropriate content. This balance between supervision and privacy poses complex dilemmas. To what extent can parents review the digital content their children consume, or monitor their interaction on social network and messaging platform? The answer to this question depends on the specific situation, the age of the minor, and the possible risks to which they are exposed. Current regulation offers some guidelines, but the interpretation of this norm is left to the parents and in some cases to the court. Data protection is a fundamental right in the digital environment, and in the case of minor, it requires careful supervision by parents. Article 7 of our organic law established that consent for the processing of personal data on social network and information society service can be given starting at the age of 14. This means that minors under that age need the consent of their parent or guardian to register on digital platforms such as social network or messaging application like WhatsApp, as I say. This right to data protection implies that parents are responsible for supervising the processing of their children's personal data if they are under 14, and deciding whether to authorize their participation on this platform. It is also the duty to review the terms and conditions of digital service to ensure that they do not compromise their children's privacy and security. In practice, however, many minors access social networks without meeting the legal minimum age, sometimes with the tacit consent of their parents. This presents a difficult problem as well. Parents allowed access, the child's lack of maturity can expose them to significant risks, such as data collection or exposure to personalized advertising. The right to one's image and honor is especially relevant in the context of so-called sharing. This increasingly common phenomenon refers to the practice of some parents posting photos, video, or information about their children on social networks. Although parents have the right to share aspects of their family life, it is important to consider the impact that this practice can have on the child's digital identity and the right to decide on their own image. In recent cases, the court have begun to intervene to protect the image and privacy of minors. As relevant example, in this area, the Supreme Court in 2019 established that the use of a minor image on social network by one of the parents requires the consent of the other parent in case where they are separate or divorced. In this case, the court emphasizes that the minor's right to their own image prevails over the parental authority of the parents to post content that may infringe on the child's privacy. The case law on this subject reflects the growing sensitivity to the impact of social network on the privacy of minors and the need for parents to act responsibly. Although parents have the right to document moments of their children's lives, it is essential that they consider the long-term implication and respect the minor's right to decide on their own digital identity when they reach maturity. The duty of parental supervision in the digital sphere implies that parents must monitor their children's access to the internet and their activity on social network, entertainment platform, and messaging application. The duty is especially important in the context of digital parental authority, as the digital environment presents a specific risk for the minor. Parental supervision, however, should be proportional and adjust to the child's age and maturity. For young children, control can be stricter, including the use of parental control application that limits access to inappropriate content. For teenagers, supervision should be adapted, promoting a dialogue about safe internet use and respecting the right to privacy to a greater extent. In Spanish case law, there are judicial decisions that reinforce the idea that parents must ensure the protection of their children in the digital environment. For example, in a case of the Supreme Court of 2018, it was determined that parents were responsible for monitoring their teenage son's internet use after discovering that he had been victim of cyberbullying. This ruling reaffirmed the importance of the duty of vigilance and the active role that parents must play in protecting their children in the digital realm. The exercise of digital parenting is filled with tension between the child's right to privacy and the parent's duty to protect them. For example, parental supervision over their children's device can generate conflicts regarding the child's privacy. Parents must act in the best interest of the child, but at the same time, be aware that excessive supervision could result in an intrusion into the privacy and autonomy. One of the most common conflicts arises when parents want to access their children's browsing history or social media profile. While this supervision can be justified in some situations, excessive control could be counterproductive, limiting the development of autonomy and the child's ability to responsibly manage the digital life. For this reason, digital law and child protection experts recommend that supervision should be based on dialogue and early education on the appropriate use of technology rather than constant monitoring. Additionally, in situations of separate or divorced family, decision-making regarding the minor digital supervision can be especially contentious. In these cases, disagreement often arises between parents over the minor's access to social network or the publication of their image online. This disagreement can lead to legal dispute in which the court may decide based on the best interest of the child and the right to privacy. Digital parenting in Spain does not have a specific regulation in the civil code, but the interpretation of articles related to parental authority, along with data protection and digital rights regulation, provides the foundation for this concept in the digital sphere. European regulations are also relevant in those matters. Over the year, the Supreme Court has addressed various issues related to minor digital rights and parental authority in the digital sphere. This ruling have helped to define the scope of parents' rights and duty in supervising the digital lives. For example, we have a Supreme Court ruling on minor right to image that the Supreme Court of 2019 determined that publishing image of minor on social network must adhere to proportionality criteria and require the consent of both parents in case of separation. Another ruling of the Supreme Court of 2015 determined that parents have a duty to supervise minors' internet access, and this duty is part of parental authority. And another one for 2010, the Supreme Court determined that parental authority does not grant parents unlimited right to intervene in minors' privacy, especially in terms of reviewing private communications such as email or online messaging. In this ruling, the court emphasized that parental supervision must be proportional and that although it's their duty to protect minors from potential risk, parents must also respect the minors' rights to privacy. From this ruling, the Supreme Court has assessed a series of fundamental principles regarding digital parental authority of minor rights in the digital environment. That it's like one, or first, consent in the use of the minor image and respect for the digital identity. Second, duty of supervision over access to social network and digital context. Is a part of the responsibility in exercising digital parental authority. And third, protection of the minor's privacy and proportional supervision. On this case law, in Spain, the Supreme Court provides a framework that guides parents in exercising their digital responsibilities, establishing limits and protecting minors' rights. Through these rulings, the importance of parents acting prudently and respecting their children's privacy in the digital environment is recognized, while still fulfilling the duty of protection. The Supreme Court has laid down fundamental principles regarding social media access supervision and minors' privacy, highlighting that digital parental authority requires a balance between protection and autonomy for minors. Although there is still no specific regulation on digital parental authority in the civil code, this ruling represents progress towards an interpretation that allows parents to protect their children in the digital realm, respecting the fundamental rights and promoting the responsible construction of the digital identity. The exercise of parental authority in the digital environment faces numerous challenges, mainly stemming from the rapid evolution of technology and the need to balance parents' right to supervise the privacy and autonomy of the minor. This challenge can lead to conflict that require carefully handle both in family and judicial settings. Now I will say some of this challenge, that is consent and access to social media. Here, the access, which we find several challenges like supervision of minimum age compliance or conflict over the minor's autonomy. In some cases, these conflicts can reach the court, where it has been recognized that access to social network for minor under 14 requires the consent of both parents, especially in separate family. The Supreme Court has resolved cases in which one parent requests limited access to social network, considering that the minor was exposed to risk, highlighting that social media authorizations should be a shared parental authority exercise and that the minor safety should take precedence over their autonomy in this situation. Another challenge is the conflict between privacy and parental supervision. The balance between the minor's privacy and the duty of parental supervision is one of the most delicate conflicts in digital parental authority. Although parents have the responsibility to protect their children, including supervising their online activity, minors have also a right to privacy and development of their personal and digital identity. The Supreme Court has emphasized the importance of proportional supervision according to the age and maturity of the minor. For young children, the control may include content reviews and the use of paternal filter. However, for teenagers, supervision should be more flexible, adapting to the need for independence and privacy. Intrusion into the minor's privacy, such as reviewing private messages on the social media, should only be justified in cases where there is an evident risk. This right to privacy...
Please, if you could conclude, we are out of time.
I'd like to do a conclusion. Okay, to finish it because it's quite late. So, Digital parenting presents multiple challenges and conflicts for parents, especially in constantly changing digital environment. The most common challenge includes balancing supervision and privacy, consent for social network use, control over the minor, image and social media, protection of personal data, and targeted advertising. Additionally, conflict between separate parents increase the difficulty of reaching agreement on digital supervision for the minor. The Supreme Court case law on this issue emphasized the need for responsible and proportional supervision based on the best interest of the minor while respecting the privacy. The evolution of technology and this increasing participation of minors on social networks and other digital platforms required parents to stay informed and for jurists to promote interpretation and solution that allows minors to protect without interfering on the rights. Thank you.
Thank you, Abigail. Thank you a lot. A moment. Yeah. Well, now we are arriving to the end of the webinar, but we have now the Q&A session or section. If you have any question, well, we are a bit tired after this so long webinar, but perhaps you have any question? No? Well, then the closing remarks. Thank you very much for attending our webinar. Thank you for magnificent speakers. Their speaks. Oh, thank you. Have been very good, and well, after this webinar, we have we have studied several interesting themes. We have topics about transgender, migrants, and the surrogacy, the families, the civil liability in family law. They have been very interesting, and well, as we are very late, it has been taken so long. So thank you to all of you, and we finish this webinar here. We are going to place some materials in the webinar in the website of the webinar, so you will be able to see some of them very soon. So thank you, and we will see in the next webinar, I hope. Thank you. Bye.
Thank you so much.
Thank you very much.
Thanks.
Thank you to all of you.
Thank you to all. Thanks. Hope to see you soon.
Ok, thank you. Pero ¿y qué puede esto poner?